Every single client who has a prenup has estate planning gaps. And this is because of the nature of prenups. Here in California, we're a community property state. And with a prenup, what we're saying is we are going to maintain separate property characterization for assets that may have eventually become community property over time in a marriage. A surviving spouse does not automatically inherit all of the separate property. They only inherit a portion of the separate property. If the deceased spouse does not have children, then the surviving spouse will inherit half of the separate property, and the deceased spouse's parents or siblings or even their nieces and nephews might inherit the other half. If the deceased spouse has a child, even a child with the surviving spouse gets either a third or half of the separate property, and the child or the children get the rest. When we're talking about real estate, this really muddies the waters. It is absolutely critical that while you are working with a client on a prenup, or when you refer your client to a family law attorney for a prenup, you also make sure that they are working with an estate planning attorney. A prenup serves to set the rules on who gets what in divorce. An estate plan sets the rules for who gets what and who is in charge at the time of death. And I've yet to meet a couple who has handed me a prenup and said, this is the way we want the assets divided if we die happily married. It just has yet to happen. No couple should have a prenup without an estate plan, and this becomes absolutely critical when two people are blending their families or where there's a large wealth situation where one person is coming into a marriage and they own real estate with members of their family of origin, for example. My name is Patricia DeFonte, and I suffer from catastrophic thinking and paranoia. I'm an estate planning attorney, and we work with clients all over California on Zoom. You can see more videos on our YouTube channel. Please click like and subscribe.